and that can only possibly mean one thing. It's Heinz webinar time. I'm Chris Irons, former Commissioner, Body Corporate Community Management, Strata Advisor, Heinz Legal. With me today, as always, Frank Higginson, partner, Heinz Legal. Frank, welcome.
Hello, everyone, again.
We are maskless, and we are happy about that.
Yes.
So welcome to maskless. It's always been maskless, but officially maskless webinar today. Thanks everybody for continuing to sort of be engaged and be part of these webinars. Of getting really good response, really good reactions. So thanks very much. Keep that going. Don't forget to like and share. Make sure that you register. That's where you find out what's happening and when. You get reminders for that, and importantly, you get a little bit of content from us after the webinar as well. And we've got some pretty good, we've had some pretty good ones. We'll continue to have some pretty good ones as well. Don't forget also, I know that we're only partway through April, but when we get up to May, we'll release our next set of topics for May. There'll be some good ones in there, Frank. We've got a few follow-ups that we're yet to do.
Banking up follow-ups. So yes.
Which is good. Today, resident managers, Frank, where good resident managers go wrong.
Yes. So it's been a very, I suppose you'd say, body corporate focused webinar series. I mean, crikey, it's almost 12 months we've been doing these now. And of course, new regulation modules sort of bump a fair bit of content down the line because there's, I don't know, probably about 8 or 9 of those that we did. But we do have a very large management rights practice. We act for lots of management rights owners. And so we need to start to producing some specific management rights content, which is what this is. And I think probably the easiest place to start are some of the more regular conversations we have with management rights clients and I suppose committees to a lesser degree, but part of, for me, what these things are is de-escalating things, helping people understand what they should and shouldn't be doing. And today we're going to rattle off, I think, a whole bunch of, it is, as you say, where good managers go wrong. Like, I don't think no one, well, I'd say no one, because I mean, the exception always proves the rule, doesn't it? Some people do intentionally want to do the wrong thing, but the vast majority of people everywhere want to do the right thing, but sometimes they just might be a little bit misguided, don't necessarily understand their roles and responsibilities, don't understand what they should and shouldn't be doing. And today is part of our attempt to start with management rights owners in terms of some of the things we see, common mistakes, that'll make their lives easier, and inevitably, I suppose, their committees, their strata managers, their lot owners' lives easier as well.
Tenants too, for that matter, I suppose. Definitely. So, as you say, Frank, while this is, I guess, primarily for the resident managers out there, this has wide application for pretty much everybody involved in the body corporate, where there is and we're using the term resident manager today, but they go by other terms as well: on-site manager, caretaker, a few other things as well. I reckon the first thing to say, in my experience, Frank, where most problems begin and finish is in body corporate land, and same in management rights land. It's a lack of understanding of roles. Everyone in life plays a role, has a role, but I think in body corporate and management right land in particular, roles and role definitions are absolutely critical, aren't they, Frank? Because everything in legislation is prescribed to the nth degree based upon who does what.
Yes. And I mean, that applies equally to committee members. It applies equally to body corporate managers. So I suppose next week we've got a body corporate manager specifically focused webinar. And so, and I suppose you'd say from a legislative perspective, a resident manager, and resident sort of implies they reside on site. Some don't, which again is part of I suppose we've moved from what management rights were 20 or 30 years ago into a different environment today where there are more off-site management rights. You'd start with saying that the legislation defines a resident manager, as a caretaking service contractor who also has a letting authorisation with the body corporate. So that's the starting point. That's, if you fit that statutory definition, then you are a management rights owner. There is a management rights agreement in existence for your building. You might own it and run it. But after that, and this is, I suppose, what we're talking about today, every single one of them is different.
Yep.
There's no when you buy a management rights business or you buy a piece of real estate, there's a standard REOQ contract. Everyone uses the same one. There's a couple of alternatives out there contract-wise, but really everyone knows the REOQ contract. They know what it says and they can sign it and away you go. From a management rights perspective, the key thing, I suppose, to start with almost is each agreement's different. And albeit that there are some that will look the same because they're produced by the same law firm, they might have the same set of duties, but every scheme is different. And the longer they go, the more likelihood is that they're going to be more different from every other building. So there is no standard form management rights agreement out there.
So what does that mean? In other words, Frank, don't ring up the Commissioner's office or a lawyer and say, I need to know what the contract says for management rights in relation to blah, because the answer is going to be the same every time. Depends what's written there. Yep. There is no set answer for you on any given part of a management rights contract.
Yep. And if you want the genesis of almost, I'd say more than 95% of management rights disputes, it's going to be around the performance of the duties.
Yep.
You can have technical legal arguments, absolutely, but they are few and far between. It is going to be about the duties. And I think from a management rights owner's perspective, the most important thing you can do is read your agreement and understand the duties, do it again, and do it again, and then pull it out in 3 months' time and do it again. So you understand what it is that you're actually required to do.
And ideally, Frank, that happens before you enter into the agreement. If you don't do it before you enter an agreement, then make sure you're doing it afterwards. And there are plenty of resources out there to help in that regard. We have a stack on our website, Commissioner's Office, various other places as well. Yeah. We were just talking about duties, Frank. So let's go through some of because the topic was where good resident managers sometimes make mistakes. So let's go over some of those. I guess one of the first ones when we're talking about duties, well, this sounds a bit oversimplified, but Frank, if you've got a task, you need to be doing it.
Do it.
Yeah.
Do it. If it says clean the pool daily, make sure the pool's clean daily. You know, and this is part of the understanding the duties, because I mean, where the industry should be getting to, and I'm a big fan of them, is really prescriptive schedules of duties. So we're not talking about mow the lawn as required, which is very nebulous. Required by who? To what standard? And that's where a lot of the fights can start. So if we're going to mow the lawn once a week in summer and twice a week in winter, then that's what you do.
Yeah,
it's right. And make sure you do it.
And leaving it unattended, either because you dispute that you have to do it, or because you don't understand, or there is some negotiation going on. That's almost guaranteed to lead to a dispute somewhere. Yep. Leaving something untouched, unknown, unattended to, you can guarantee will result in a problem. So step one, if you've got a task, you either do it or you have a discussion and get to a resolution about a different way of doing it.
Absolutely. And have that discussion with your committee.
Yep.
Because it's the ignoring of those, those grey areas, and there's going to be some. Don't ever get me wrong, there's always going to be some. There's always elements of interpretation in duties and all those sort of things. Having the conversation is a much, much better place to start than getting a nasty letter from the committee saying you're in breach of your agreements. Yeah. Get in front of it. If there's an issue and you think there's an issue, have a conversation.
That's right.
Yep.
Next up, don't forget that for most resident managers, in fact, I think the vast majority, Frank, of resident managers, you'll be an owner as well. And don't forget that as an owner, you have a vested interest in making sure that the scheme looks good. So it's not just because you have a management rights agreement that you want to make sure common property looks good, is it, Frank?
No. You're protecting the value of your own real estate investment, and more importantly, everyone else's real estate investments. Because if there is a way to get people's attention, it is to muck around with money and their money. So if people think that your failure to do something is going to cause them some sort of financial consequence, then that tends to sharpen the spears a little bit quicker than anything else. So again, getting ahead of that is really important. But by the same token, I think probably the next thing, and this is where I think some managers, again, having the conversation about, go wrong, is managers usually aren't necessarily, they're not a decision maker for the body corporate. You know what I mean? In a sense, not in a sense, I mean, a manager is a contractor to a body corporate the same way that we would be as if we're acting for them. The difference is that ours is a fee agreement for usually a particular matter that can come to an end on a moment's notice. A management rights agreement is a contract for service over a period of time with a defined schedule of duties and remuneration. But inside that, it doesn't necessarily mean that the manager can go and make decisions about cutting down trees, about replacing pool pumps, about repaving tiles, about painting walls green rather than white, because they are, what they might have under their agreement is an obligation to trim trees, to manage the removal of trees if instructed by the body corporate, to supervise painters in relation to the painting of common property. But those decisions to actually undertake that work rest with the committee or the body corporate and general meeting, subject to, you know, the usual spending limits and all that sort of thing. A lot of managers get themselves into strife by charging on and doing things that they think should be done.
Yep.
But actually they should be getting instructions from the body corporate to do it. And the easiest example I can give for that is if we're in the middle of a transaction, we're acting for a client, selling or buying, we won't go and ask for an extension for adaptive finance approval, for example, or agree to one requested from the other side unless we've got instructions to do so. So a client might say to us, Frank, absolutely, if they ask for an extension for the next 3 months, just give it to them. Okay, I'll do that up to that period. But other than that, we'll go to the client and say, hey, the buyer wants to go to the 24th of June. Are you okay with that? The client says yes, then we act on it. And that is exactly the same with management rights. I think these trees should come down. I've got quotes for them. Let me know what you want to do. The line gets crossed when managers charge on and knock them over without getting committee approval, or at least understanding their committee.
Frank, I can't think off the top of my head of one instance under the body corporate legislation where a resident manager is a decision maker.
They are.
Can you?
No. No, and this is where, you know, managers try to be proactive. They try to get in front of things. They try to look after the common property in the way that they think it should be looked after. But that's not recognising that they're actually not the decision maker. They need instructions to do those things. And that's that good intentions to deal with things in a effective, immediate, take the pain away from the committee type manner can sometimes lead to problems when the committee says, what the hell are you doing that for? We had a plan for those trees and it wasn't that. That's simple misunderstanding about roles.
Very much so. And that leads very nicely to the next mistake that good resident managers make, and that's in relation to bylaw enforcement. This is a classic one that we see all the time, isn't it, Frank? Where you've either got a resident manager who believes that it's their job to be the police for the building, or you've got a committee who believe it is the resident manager's job to be the police for the committee. Neither of those is correct, is it?
Nope. So, and I suppose we've got a million webinars on bylaws. And really, this one comes down to, I suppose, the statutory position is the body corporate committee is the only entity that can enforce bylaws. That's the starting point. So if there is any formal proceedings to be taken, bylaw breach notices, all that sort of stuff, it's the committee that should be doing it. And I suppose I've had one client who was near, I'm pretty sure was suicidal about this stuff, where people were parking in the visitor parking, and he had been tasked by the committee to go and stick those really big signs, you know, the stickers on the windows that take forever to get off. And if they didn't move, to go then bang on the doors and demand people move their cars. And of course, he was copping the abuse and the pushback and all that sort of stuff from those owners when it wasn't his job. Everyone knew the bylaws were being breached. So where I think a good resident manager fits into this, I suppose, and there's a couple of arms to this. First thing is understanding what the bylaws are. Part B is whether they're enforceable. That's another thing entirely. But then trying to manage the process in a delicate way so that if people are breaking the rules, that they might be gently drawn to their attention. Mate, the committee's not really going to like you parking in that visitor spot for much longer. Just giving you a heads up. They tend to take that personally. And then reporting that to the committee to say, well, I've spoken to Chris. He continues to do it. Up to you guys now to do what you want to do with it, because I've done as much as I can. You know what I mean? And that applies to owners. When it comes to tenants, it's a little bit different. So in a sense, a resident manager who's also the letting agent for a property wears two hats. There's the caretaking service contractor, which is really where most management rights agreements will say they've got a duty to monitor the observance of bylaws and report breaches to the committee. The other one is as a letting agent for the owner. So it might be Chris is so-and-so's tenant and I'm managing the property for so-and-so. So what sometimes happens is the committee might say to me as the letting agent, go and sort out your tenant. And the tenant's got an obligation to comply with the bylaws. But my issue as letting agent is that I'm only then going to act on the instructions of the owner to go and do something with respect to Chris. So it can get a little bit messy, but I think the very starting point is a couple of different hats you can wear. It's not a resident manager's job to go and belt the daylights out of people when they're breaching the bylaws. And that is absolutely a cause for consistent disputes and issues for resident managers, because and depending on how they handle it, and I suppose the next level is not even acting on the committee's instructions, just going ballistic off your own bat without instructions because someone's breaching the bylaw. That is a recipe for disaster.
Absolutely. Look, there's been various discussions over the time about possibly changing the laws, changing body corporate legislation to make the resident manager be responsible for enforcing bylaws. Hasn't been taken up though, and I would be surprised if it did, frankly. But yeah, anyway, it's a really good point, that one, Frank. I think bylaws continue to be so grossly misunderstood in general, and that this particular bit is one big bit of that misunderstanding. Yep.
And scorched earth policies usually never work. That should be last for me. Because people hear this all the time. You never lose the right to go scorched earth, but if you start with that, there's no backing down from it.
That's right. Yeah. That's why it's scorched earth. The
Genghis Khan-like.
Genghis Khan. The next mistake good resident managers make, Frank, in relation to spending limits.
Yes. Now, this is a hill that you do not want to die on.
No.
And I have one of these conversations once every 1 or 2 weeks, I reckon. So what most management rights agreements provide is the ability for the resident manager to be reimbursed expenses that they incur on behalf of the body corporate. So when it comes to expenses of a resident manager under a management rights agreement, it's probably two different types. There's the caretaking equipment, and then there's the caretaking materials. So equipment, mops, rakes, lawnmowers, whatever it might be. The materials is going to be fertilizer, pool chemicals, fuel, whatever it is. Yeah, absolutely, all those sort of things. So it's sort of 50-50 in terms of who supplies equipment, but it is probably 99.9% of the time, it's the body corporate's responsible for the cost of materials. But the issue then comes is that most agreements will say manager will get reimbursed up to $500 or $100 per item or whatever it might be. And for whatever reason, the committee puts the handbrake on. It says, no, we don't want you to go and spend money unless we authorize it first. And the reality is that no matter what your contract says, it is not worth having World War III over that. It really isn't. So from my perspective, and you can if you want, but you're going to spend a whole bucket load of money and create a whole bucket load of angst over something that doesn't really, in the long run, add any value to your business or your relationships. That's the commercial reality of it. So it's body corporate's money. If the body corporate wants to dictate how and when it's spent and approve it in advance, then in a sense, that's not an unreasonable position. And that's the same position that we would take with clients. We're not going to go and spend money on your behalf without your instructions to do so, even if we've got it in trust. So, so that's where, okay, if you want, and normally those sort of requests come about because there's been some lack of trust somewhere, some perceived dudding, some perceived kickbacks. You don't know where. Might be that the new treasurer's had a particularly bad experience in another building somewhere and they want a really tight rein. Might be that they got voted in because they said, we're going to cut costs. And that's the first thing they're going to do. So, okay, we're back to it. I need to go and spend $15 on fuel. Can you confirm I can do that? Yes, you can. Okay. It's a pain in the ass for a period, but eventually when you get that level of trust back, or a new committee or whatever it might be, you come back to normal. But that's not usually, for me, a fight you want to have. It might be as part of an overall program. If you've got 15 other things you're bluing over, then absolutely. But as a standalone thing,
Yeah.
be Elsa and let it go and work within their framework, because it's their money. It's body corporate funds.
See, I've got this vision now, Frank, of resident managers standing out by the pool, performing Let It Go.
Let it go. Well, normally we talk about Orwell. Today we've gone Disneyland.
Yeah.
There you go.
I like it. I like it. Look, no, but look, in all seriousness, that's a big one. That one, I've heard that discussion in various forms as well, numerous times, Frank. And of course, whenever it comes to money, it's always a big deal.
It
Big
focuses
deal.
people's attention.
Mm-hmm. Yep. Quite right.
Absolutely.
Probably one of the other another area in which resident managers can make mistakes is in relation to another kind of manager, the body corporate manager. So many managers flying around. But look, one of our very close colleagues, Frank, talks about the triangle of cooperation between committees, resident managers, and body corporate managers. And what that really means is that if everyone is working together and on the same page, if those three entities all know what they're doing, then everything is smooth, body corporate chugs along, happy days. For the resident managers, Frank, there's a particular need, isn't there, to ensure they're cultivating the most productive relationship they can with the body corporate manager.
Absolutely. I think, and look, body corporate managers are always going to look after what their interests might be. But when you look at what, as everyone does, so that doesn't mean necessarily that they're going to come out against their client for you at any given point in time. And I think sometimes resident managers need to realise that a body corporate manager is never really going to take a position against a committee, even if they know the committee's not necessarily doing the right thing, because the reality is that that's going to put the body corporate manager's gig at risk. So that's the commercial reality of it. But by the same token, subject to who you're dealing with and all the rest of it, what you want is that body corporate manager to be a friend to the greatest possible degree, where they can help you out with questions and help you out with issues and give you heads up on problems that might be coming and all that sort of stuff. At a minimum, you don't want to be a headache for them, because it's sort of, it's like in a sense, the resident manager has one building they're looking after. They've got 50 owners. They've got 30 in their rental pool. They've got one committee. That's their management world. Body corporate managers might have, subject to which manager they're with, they might have 50 to 100 buildings, maybe more if they're managing a small portfolio. And so they come in from a weekend and they've got 100 emails there from everyone whinging about all sorts of things, and inevitably some of the stuff we're talking about today. And so the last thing you want to be is another one of those emails which is causing them grief. You want to make their job simple. You want to help them out. You want to make it easier for them to manage their relationship with the committee, which makes it easier for them to get reappointed and look good. And in turn, inevitably, what they will do is not cause you any grief because you make their life easier. That's just, and that's not even an understanding. That's just what happens. If you cause people grief, they tend to be able to cause you grief back.
Not even if they're intending to, Frank. It just happens. It just happens. Absolutely. So that's a really important relationship to cultivate. And I've said this so many times in webinars, you don't need to be besties in body corporate land. In fact, you probably shouldn't be. You need, though, to have the minimum relationship required to ensure that things move along without incident, without disruption. The minimum required. Yep. Absolutely.
And I mean, we get work from body corporate managers because we make their life easy. We get work from hopefully resident managers because we make their life easy. So if you go through your business environment trying to make other people's lives easy, that will produce benefits. So, and I suppose the other thing for that is taking on your body corporate manager and having a red hot go at them is usually not conducive to a good long-term relationship. It might be if they're causing you an enormous amount of grief and you need to execute them, then so be it. And vice versa, that happens. But again, body corporate managers don't go through life looking for fights because they're busy enough as it is. They don't need them.
Absolutely. Which kind of leads itself nicely to our next mistake that resident managers make, Frank, and that's picking fights where that is not needed and not required. I think, Frank, you've alluded to this several times in this webinar already. Sometimes there will be a need to have a fight, about something. Absolutely, you can't avoid that. And it's not as though you have to relish having a dispute, but you sometimes have to have it to get a resolution. Well and good.
A lot of the times you don't.
Yep.
And that's the picking your fights you need to. It's sort of, I think probably the question, and again, I have this conversation a lot with resident managers, is tell me what advantage this brings to your business. So we're about to threaten someone or do something, or we're upset about something. How does this help your business? It's a really interesting way to frame it, because if it's a point of principle, then it's not necessarily helping your business. Then it might be best to let it go, as much as that night might not be the tastiest thing you eat that week. That's just the reality. Some people are not going to be happy. Some people are going to do the wrong thing. Some people are going to go off half-cocked. It doesn't mean you have to as well.
It's that classic, Frank, and I remember very clearly someone I used to work with many years ago said to me, is it principle or is it principle? Because there, as everyone hopefully knows by now, I'm really into words and spelling and so on. There are two different kinds of principle in the world, aren't there, Frank? There's principle, which is what you believe in, what you're prepared to die on a hill about. And then there's principle, which in this case means moolah. So which is it? Is it principle or is it principle?
I got to tell you that I've got a couple of really good anecdotes for this one, but I'll only do one.
Yeah, no,
this is one. Yeah, I'll give you one. So this is one where chairperson's son was a laid pavers, whatever, gardener, whatever it might be. Who lays pavers for a living? What do you call that? Paver layer? I don't know, whatever. Anyway, his business was laying pavers. So what happened? Pavers need to be relayed. Wasn't in the manager's duties to do it. So the manager's job, to the extent of it, would have been supervising the contractor, making sure they came in and left and the job looked okay and blah, blah, blah. So there's no financial disadvantage to us in terms of doing it. Chairperson's son got the gig. The committee knew that it was the son. None of the owners knew that it was the son. Chairperson voted on it. The resident manager wrote a letter to all owners saying, this guy is a grub, this is what he's doing, all that sort of stuff. And it was just like, mate, this only came to me after the committee blew up and had a crack at him. And of course, they're having a crack at him about something else, which he hadn't done right. So again, it's it's just like one of those things. Why did you do that? There was nothing other than a point scoring exercise and a public shaming of someone when there was no financial incentive of you to do it. Absolutely, it's not right. But the moment you start putting your head up above the parapet and then pointing fingers at people and saying you're not doing the right thing, that instantaneously means other people are going to try to do the same thing to you. And this committee absolutely did, because he wasn't squeaky clean on some of his stuff. And that's the consequence of picking a fight you don't need to. Completely unnecessary.
How many times have we seen in public life, Frank, people who, are fighting for what they believe in? I'm going to fight to the death for this one. I'm going to fight to the end. I'm going all the way to the High Court, blah, blah, whatever. And then you see them at the end of the process and they are a broken person. They are broken financially. They're broken emotionally. That they have lost all sense of who they are and who they were because they pursued a principle. And we're not saying, Frank, don't pursue something that you believe in. Absolutely do so, but pick and choose.
And be aware of the costs. Be aware of the costs, financial, emotional, time, and otherwise, which litigators, as a rule, aren't good at explaining to their clients. You know what I mean? The best one for me is sort of say to clients, at the end of this, there will be blood all over the floor, and none of it's going to be mine. Even if you win, it'll be yours. So just be ready for that, because that's what we're going into.
That's right.
And it's always the people fight for principles are the ones who've never really been involved in a lot of litigation.
That's right.
They tend to do it once.
That's right. Look, and I think it really reinforces the point for resident managers. The biggest mistake you can make is to try and take a side in a body corporate. By all means, cultivate relationships. Make sure you're on the right side of the numbers. I always say, body corporates, just like politics, it's a numbers game. So make sure you've got the numbers for sure, but don't pick sides. You should be trying to be as neutral and as impartial as you possibly can in this situation, because
if you can be Switzerland, isn't it?
Owners and committees come and go, but you're there. That's your life. That's your livelihood. You're the one who's got to try and make it work over a period of time. Frank, we've come to the end, and we have a stack more that we didn't even get to.
Yep. So that's part 2.
Another one.
Yeah.
Now, I think the learning from today, Frank, yeah, let it go, and that's really not easy in a body corporate context. I know this from experience, how difficult it is for people to let go of issues that occur in a body corporate. You don't want to let go of them because you feel like you have to see this through. But as Frank has said, I think several times in this webinar alone, sometimes you will have to let it go if you're a resident manager for the greater good, the bigger picture. Your investment.
Your greater good. Your greater good is the reality. I mean, same thing happens to us every day. You get little snipes and whatever. And it's, you know what? Next. And in 3 months' time, will I remember them? Nope.
Well, you might remember a few, but
Yeah,
that's okay. That's okay. You can hang on to that if you. That's fine. It's not letting it affect good decision making. It's not letting it cloud your judgment thereafter. Yeah. Well said, Frank. And I really like the Disney introduction today. It's been good. That's it for today. Thanks everyone for tuning in. Really appreciate it. Again, don't forget to register when we send out the reminders on social media. That's how you will obviously get reminded that we're on. Next week, as Frank said, we're talking about a different kind of manager, body corporate managers, and in particular, how to improve the relationship with your body corporate manager. That's going to be a good one, I think.
Treating them like an adult would probably be a good start sometimes.
Oh, no, come on.
No, everyone treats everyone else with respect, Chris, all the time in Strata.
Geez, again, come on. What do you think? That's it from us for today. We will, Frank, thank you.
Thank you, mate. And
everyone,
thank you everyone for joining us again.
We'll see you next week.